The court will now proceed to the fourth and final case on today's docket. Florida Department of Health versus Florigrown, LLC. Counsel?
Mr. Chief Justice, and may it please the court. I'm Joe Jaco with the Governor's Office, representing the Department of Health. And with me today is Daniel Bell for the House of Representatives. I wish to reserve a minute for rebuttal. The order below is a separation of powers concern, when, as here, the statute does not directly conflict with a proper textual interpretation of the amendment. Medical Marijuana Amendment Section 29A sets up an immunity for MMTCs. 29B5 has two conditions for that immunity. First, an entity must be within a larger set of performing one or more of the listed activities. And second, the entity must be in the subset of registered by the department. Then Section 29D calls upon the Department of Health to regulate registration, and 29E invites the legislature to further regulate under its authority. Nothing in the amendment prescribes a horizontal market model, nor does the amendment elbow out the legislature's vertical integration of MMTCs. However, Florigrown makes three mistakes interpreting the amendment for MMTCs on immunity, on registration, and on legislative regulation. First, Florigrown misreads B5's use of the word "or" on the scope of immunity to falsely assume a mandated horizontal market. Second, Florigrown overlooks B5's registered by the department requirement, on which both the Department of Health and legislative regulation actually operate. And third, Florigrown avoids the amendment's full context on registration, on which there is not just a ministerial duty, but under Section D, MMTCs must be regulated, including with licensure on caps as deemed by the legislature. And as the amendment doesn't address MMTC license caps, there is no direct conflict for this certified question. We ask this court to properly interpret the amendment and overturn the injunction.
Counsel, can I ask you a question? It seems part of your argument in the briefs, it seems like you want us to interpret the statute the way we would normally interpret a statute in terms of almost this kind of rational basis review, given that, you know, it's an economic regulation. But since the Constitution says that the regulations issued by the department have to be reasonable, and they have some kind of goals of the regulations and some of the scope of the regulations here, doesn't that kind of change the nature of our review in the sense that the question for us wouldn't be, or for the court, it seems like would have to involve fact finding, but instead of asking ourselves like we would in a normal case, could a legislature rationally require vertical integration? Instead, it seems like the Constitution would require us to ask, you know, given all the facts that might be presented in an actual, you know, trial, is this in fact a reasonable approach?
Your Honor, while we do think that the statute has a rational basis, the question that's certified to the court is purely a question of whether the statute conflicts with the amendment. And that's just a question of interpretation of the text of the amendment.
I guess my point though is that we couldn't really know, because this arguably changes the standard of review, it circumscribes the discretion that the legislature ordinarily would have had. I don't know that we could just say as a matter of law that requiring vertical integration is necessarily reasonable. I mean, I'm not saying I agree with the way the first, I think you're right about the way you interpret the definition of MMTC. The amendment doesn't tell you how it needs to be regulated, whether it's vertical or horizontal or whatever. But I guess my question to you though is that how could we say as a matter of law that a particular regulation or statute, and I think really the statute can't be, you can't have a statute that's unreasonable, but in conjunction with a reasonable regulation requirement in the text. So how can we say as a matter of law that this statute is reasonable?
That's right, Your Honor. The amendment does not dictate any kind of market model. Certainly it doesn't dictate a horizontal model. The question for the court is a question of this injunction, right? A question of the likelihood of success on the merits for the purpose of this injunction. So we're not asking the court to get into the reasonableness. I mean, and certainly in relation to the caps, we would say you don't have to at all. There is no direct conflict between the amendment and a requirement for MMTC caps. Rational basis isn't a question for the court today. But certainly the interpretation, the proper interpretation of the amendment is, the amendment section 29A provides immunity when an MMTC is, quote, in compliance with this section and the Department of Health's regulations. And accordingly, the MMTC definition in B5 has two prongs. The first is that an entity must engage in one of the listed activities, and that establishes a potential immunity or the universe of immunity that may be gained. But the second prong is whether an entity is registered by the department, and that is for the actual immunity. And that is the place that both the department's regulations on registration and the legislation has taken action. So in essence, the statutes and does not replace the amendments or. If you look at the chart on page 26 of Florigrown's brief, that's an apples to oranges comparison. The statute requiring vertical integration is a matter of registration regulation. It does nothing to affect the immunity, the broad scope of immunity that may be available to any one of these activities. And just because the legislature...
Can I interrupt and ask a question? Given the general principle of judicial restraint that we don't address a constitutional issue if there are other bases for deciding the case, and given that the constitutional issue is only preliminarily decided in the case below, if we find that there are other reasons why the preliminary injunction should not have been entered, such as a failure to meet one of the prong of irreparable harm, should we even address the constitutional issue?
Well, you should for two reasons, Justice Lawson. One, both the Department of Health and Florigrown are seeking it. So we are in alignment that we're seeking a decision on the substantial likelihood of success on the merits. And second, if this court doesn't, this issue is going to continue. It's going to be an issue when it goes back to trial. It's an issue in forestalling the overall process of regulating MMTCs. You've seen the litigation flourish, and this court can properly interpret the amendment to provide that ability to move forward with clarity under the statute. Let me just make a second point here, and that is, what does registration actually mean? Registration of an MMTC is more than just a ministerial duty under the amendment. This litigation began with Florigrown drafting its own premature registration letter, and the amendment, though, requires much more than that. Section 29B's requirement that an MMTC must be registered by the Department of Health should be read in context with Section D as well, which sets out regulations for procedures for registration. The amendment's full terms on registration show this is much more than just mere paperwork. Section 29B5 demands an entity is registered by the department, not with the department. This isn't a passive role of the department accepting a piece of paper. This is an active role of the department applying the regulations on registration. And when we look to section 29D1C, we see what these procedures are. They're one, the issuance, renewal, suspension, and revocation of registration. That's clearly more than mere registration. That's more licensing-like. And we also see standards to ensure safety, security. These are the kinds of things that you would also expect of a police power, that you would expect the legislature to act on. And indeed, the amendment invites the legislature in subsection E, titled legislation. This is true because if there wasn't a robust requirement for registration that is like licensing, then Florigrown could merely submit its application, get rejected, or have the registration revoked, and then the next day just re-register. But instead, this court's own ballot initiative recognized that DOH's role was, quote, overseeing and licensing, and it saw that DOH's role would not impact the legislative function. Thus, the amendment does not preempt a legislative regulatory scheme. Let me hit the third issue quickly, which is, does the amendment actually invite a responsive legislature? You heard in the argument earlier this morning on the adult use question that council mentioned this may circumvent a non-responsive legislature. Here we have a responsive legislature. They have taken action, and they've taken action under the amendment. The legislature, in doing that, has used its plenary authority, which is what you'd expect when we're talking about regulating something that is illegal under federal law and illegal under state law for recreational use. This is seen in the amendment in section D, which calls on regulations for the availability and safe use of medical marijuana. And this is not just the legislature acting under some guise of an exception in subpart E, but this is the core power of the legislature that this court recognized in its ballot initiative to make policy. Otherwise, this ballot initiative would have violated the non-delegation doctrine, much less does it strip the legislature of its regulatory role. Your Honors, I would, if there are no further questions at this time, reserve the balance of my time for rebuttal.
Counsel, please proceed.
Mr. Chief Justice, and may it please the court, my name is Daniel Bell, and I'm General Counsel to the Florida House of Representatives, and it's my pleasure to appear today on behalf of the House and in support of the department. I agree with what Mr. Jago has said today, and I think he's done an excellent job walking us through the text. I'd like to start with the few minutes I have with addressing your concern, Justice MUNIZ, regarding the potential scope of judicial review in a case like this, and whether the amendment modifies traditional rational basis review. Is that a fair understanding of your question? So first, I'd like to start by saying that in this case, as pleaded in the operative complaint, Florigrown did not argue that the vertical integration requirement was unreasonable. So this issue hasn't been fully briefed. But what I would say is, I think that if anything, the text of the amendment calls for traditional rational basis review, if not for perhaps even curtailed review in this area. And that's for several reasons. First, the phrase reasonable regulations, I think, is a fair textual call out to traditional rational basis review, because of course rational basis review is the familiar standard in which the question is whether the legislature could have reasonably concluded that the law serves a permissible government interest. And then in the next sentence of the text, what we see is several enumerated textually expressed permissible government interests, including safe use and availability of this drug. And
I'm sorry to interrupt you, but isn't it, normally the legislature gets to choose its ends. And the question would be, is there any rational, can you ascribe any kind of rational understanding to why they would have pursued them a certain way, or how they chose the ends? In this case, though, the text tells the department what the ends of the regulation has to be. And you could read it as, almost imposing an obligation to ensure the availability of this stuff. And so I don't know that rational basis review really translates. I mean, in a normal APA case, you have a legislative command, you have regulations. Obviously, there's much more searching review of the regulations to see, are they justified factually? Is there a proper fit between means, ends, et cetera, et cetera? And I kind of struggle, given that, for better or worse, and I think the court may have been a little bit overly optimistic in its opinion approving this as to how there wasn't, that it wasn't really changing kind of key separation of powers principles. But, given that it's authorizing the department to regulate, telling it what the goals of the regulation need to be, and imposing this reasonableness requirement, that doesn't sound like rational basis review.
So I'm happy to address that, Your Honor. So a couple of points. First, I think it's important to recognize that the textually stated goals of availability and safe use are inherently competing. And I don't think we can read into the requirement, certainly not a judicially enforceable requirement, that the legislature provide for the availability of the drug. And that's for several reasons. First, because availability, much like adequacy in the context of the education cases like Citizens for Strong Schools, is an inherently subjective standard. And it's particularly so when the text commands not only availability, but also safe use. I'm not sure what judicially manageable standard the courts would be able to deploy to determine whether either of those goals had been met, and particularly whether they had both been met or in any particular balance. And so I think it's a fair reading to say that judicial review in this area calls for the court to look to whether the legislature could have reasonably concluded that the law is going to further those interests in availability and safe use, and that is precisely what this law does. So the vertical integration requirement, Your Honor, goes to safe use by creating the type of tightly regulated market that was called for in Department of Justice guidance that was in effect at the time that the amendment at issue was drafted. Specifically, the Cole memo that is, I'm sorry, go ahead, Your Honor.
If there are more proceedings on the merits here, it really there shouldn't be any fact finding involved.
So all I can say for now, Your Honor, is that I don't think there's any basis for the courts to look into. I think the court, I think that's fair. I think that the legislature's determinations as to whether their laws promote availability and safe use can be determined only for whether they could have reasonably determined that they further those interests, and evidence cannot really be to the contrary because it's a question of law. And I see that my time has run out. Thank you.
All right. We thank you. Counsel, you may proceed.
Good morning, Your Honors. May it please the court. I'm Kathy Giddings of Ackerman, and I'm here on behalf of Florigrown. Your Honor, I would disagree with several of the things that my opponents have stated, specifically as to the fact that we did not prove that the caps were unreasonable. There was a 2-day evidentiary hearing in this case at which both sides had an opportunity to present evidence, and I'll get into just a second why the caps are in fact unreasonable. So Justice MUNIZ, I don't think you need to get into the question of what standard should be applied because it fails the rational basis test. But this case is not about public policy. Your Honors, this court has unanimously and repeatedly said that the legislature can't come in and change the plain language of the Constitution. What the legislature is asking you to do is to allow it to change the words here. If you accept that argument, that means that the legislature could come in and say under its regulatory authority that someone would have to have all of the debilitating conditions. It makes no sense. And you look at the plain language, it uses the term or. Now, if there's any doubt on that confirmation, you look at the intent document. Now, we say it's plain on its face, but the intent document that was issued before the amendment was released, was voted on, expressly states that this was to set up a vertical system. The legislature has come in, and the department was proceeding to have a horizontal system. It was proceeding in following the amendment's dictates, and the legislature came in and said, we control you, we control your funding, and if you do not do what we say, then we're going to withhold your funding. The Constitution, it's easy to determine from the plain text, and I would ask this court to look at Garcia versus Andoni. In Garcia versus Andoni, the legislature tried to do something very similar to what it's doing here regarding the homestead exemption, and this court determined that it could not do so. And if you accept their argument, I would also say that the new amendment governing first responders, this benefits for death benefits for first responders, they could say that a military member doesn't just need to have resided in the state or have been on a post. It would change it to and.
Counsel, I'm sorry to interrupt you, though. I mean, it seems like the definition goes to it can relate to the immunity, and where we look in the text of the amendment to, what the kind of constraints on regulation are. That's in subsection D, and there's nothing in there that says, how many MMTCs need to be registered / licensed and what the criteria for that should be.
Well, Your Honor, I think that question goes more to the rational relationship of the caps, and I'm happy to get into that. But I would tell you that if you look at the definition of an MMTC, the first word is to, quote, acquire marijuana. That word would make no sense if you take out the or and you require them to do everything, because no entity would ever acquire marijuana. And so that reads in with the or. But as to the caps, the thing that you need to understand about the caps is that the reason that the court found that it was to a closed class and that they were giving these licenses away to settle lawsuits, they've never evaluated who is the most qualified. But they are not rationally related because, as the department's director testified in the depositions that we submitted at the evidentiary hearing, there is no relationship to the caps because the legislation does not control or dictate the amount of marijuana that any of these entities can process or grow. The director said that they have no control over that and that the MMTC could have a facility the size of a postage stamp, or it could have one the size of a Target. And they also just lifted the caps on the amount of dispensaries. But we have record evidence. We submitted 20 affidavits, and you can also look at the triangle brief that shows that even though there are these dispensaries out there, patients who are critically ill cannot get the products they need. And when they can, they are at outrageous prices. Remember that one of the reasons that the licensing procedure is not appropriate and is not rationally related to any qualifications is that when an entity gets that license, it can immediately turn around and sell it. Today, there are 22 licensed medical marijuana treatment centers. Of those, 12 got their licenses on open market, and they were selling for as much as $50 million. So what you've got is people have these licenses, and they're having to make money back. And so what they are doing is they are charging astronomical amounts. Florida, I believe, is up to 4 times more medical marijuana than other states. And the department has never registered one single entity. Now, there seems to be a lot of confusion here about the difference between registration and licensure. Registration, the best example that I can give you is that when you want to become a lawyer, you have to submit an application to the Board of Bar Examiners. The Board of Bar Examiners website talks about registering. Then you have to fill out all of that information. You have to show that you are a good moral character. You have to be inspected. And then you have to take the bar exam. And after you have done all of those requirements, that's phase one of registration. After you've done all of those requirements, then you are given a certificate or a license to be able to practice law. The same thing works here. In order to get a license, you register, but the department's not accepting any applications. It's never accepted one single application from anyone that was not either to settle a lawsuit or a pre-dispensing organization. And there is this laundry list of things that an entity would have to establish before they could ever touch any medical marijuana at all and get certified. And all Florigrown is asking for is an opportunity to be considered to show that it has all the qualifications. It has a nursery license. It has a physician on staff. It has a facility ready to go. It has a hemp cultivation license, but it can't be considered because of the legislative dictates. And remember that if you look at the statute, the legislature, the statute is 27 pages long. We are only attacking a very, very small portion of the statute. And there is a severance provision in that statute. And you will notice that that severance provision is only in the Section 8, subsection 8, which governs MMTCs. So the legislature was aware that when it gave these to these closed classes, that it was not going to, that there were going to be questions about this and it might be held unconstitutional. And again, the state is asking you to read words out of the Constitution. And I would call to the court's attention when Judge LAWSON mentioned the injunction. If you look at the City of Jacksonville versus Nagel Outdoor Advertising case, it states when there is a full evidentiary hearing that the court can go to the merits, and that is what the trial court did here. And it found that these were unconstitutional closed classes, as we've stated in our brief, and that there is no rational relationship between the statute and the amendment and the statutes that have been enacted. Does the court have any other questions?
Now, one of the points in the briefing was that you would have, if the rulemaking process hadn't been enjoined, that you would have been able to apply, obviously with no guarantee of success, but you would have been able to apply. So doesn't that defeat the irreparable harm argument?
No, Your Honors, because we've never been able to apply. And the amendment itself recognizes that the department was supposed to issue regulations by October 2017, and it has never implemented any regulations to register MMTCs. So the amendment itself expressly allows any Florida citizen to come in and attack or to compel the department to do its duties. The department has never done what it was supposed to do. It's never registered. It's never considered. All Florigrown is asking is to have a fair chance to participate in the process.
But wasn't the effect of the injunction that you sought to halt a rulemaking process that would have resulted in you, again, with no guarantee of the outcome, but that would have resulted in you being able to compete for a license?
Your Honor, it was it was to stop the department from issuing licenses to settle these cases. They've continued to issue licenses only to settle cases.
But but the statute and the rules there still would have been another, obviously not, limited in number, but there still would have been a number of slots that you could have competed for.
No, Your Honor, the department is not accepting any applications, and it has never accepted any applications. It continues to give those licenses to people to settle lawsuits. It gave out 8 last year. There are no licenses that are available. We've never been given an opportunity to show that our client is qualified under the statute.
I think the question was, if the regulations that were under consideration had been adopted, then your client would have been able to apply for one of the available licenses.
No, sir, Your Honor, they would not have been able to apply because they have capped the licenses, and the legislature prohibited the department from allowing anyone to apply. So as to the irreparable harm, I think you're getting to 2 elements in the injunction. One is the status quo and one is the irreparable harm. As to status quo, you go to the last uncontested, peaceable place where the parties were. Here, that is what the Constitution required. We brought this case to compel the department to do what it is required to do under the Constitution. And that was the last peaceable, non-contested position. And as to irreparable harm, Your Honors, per se irreparable harm is considered in Title VII cases, in non-compete cases, and I know that in the Gainesville Women, this court used fundamental right, but the cases that were cited in that case did not involve fundamental rights. And remember, this is what else does any citizen can compel compliance with the amendment mean if it does not allow someone to come in and get injunctive relief? There is no other way. I mean, here we are 3 years later, the department's never done what it was supposed to do. The department's regulations are not consistent with the amendment. It has not done what the amendment says.
On that point, on the amendment language specifically, under subsection 5, B5, you're comparing the language "or" in the constitutional amendment to the "and" language in the statute, right?
Yes.
Is it your position that by the use of the language "or" in the constitutional amendment, that it's constitutionally required that each type of entity doing these separate things has to be separately registered and licensed by the department?
No, Your Honor. An MNTC could do all of the things that are in that laundry list. Importantly, what the injunctions here have done, they don't touch the licenses that have already been so an entity, and again, you look at the plain language, it says "or," and then you look at the intent analysis that was published, and it specifically states that that was in there. Remember, the legislature had defined a dispensing organization using the term "and." The amendment comes in and uses "or," and then the legislature goes back and puts it back to "and."
Well, could the legislature have taken, say, 2 or 3 of these type of activities and required an entity do 2 or 3 of them and license that particular entity as a requirement, and then others as well, separately?
No, Your Honor, the amendment is very, very clear. The amendment says an MMTC can do any one of those things. And it was specifically designed to overrule the definition that the legislature had been using for dispensing organizations.
But then it seems it is your position that they have to be separately registered and licensed. They
can be, but they do not have to be. In other words, the amendment was specifically designed to allow an MMTC to do any one of those things. And that makes sense, because you don't go to the Tylenol store to buy Tylenol. You don't go to the Advil store to buy Advil. In a free market, as Judge Makar said below, he knows of no industry that uses vertical integration rather than horizontal integration. And I believe that there are 31 states that allow horizontal and follow a horizontal model, and there's 3 that follow a vertical. And the triangle brief shows that a horizontal integration system allows for more production so that you fill the availability. And remember, all of the stringent regulations in place stay there. The legislature has volumes of safety regulations to prevent the horrors that they are talking about.
So counsel, counsel, let me just follow up then on Justice Polston's question though. So you've told him that the department/legislature cannot use as a basis for denying an application for a license or registration the fact that an entity doesn't do multiple of these things that are listed in the definition. So what are the permissible grounds for regulation then?
The permissible grounds of regulation are to allow someone to register and come in and show that they can do these things, and one of these things or all of them. And the trial judge made a specific factual finding that the department already had a process in place. And if you sever the unconstitutional provisions from the statute, there are already safety regulations in place. They just need to follow them.
So basically, are you saying though that it's kind of an entitlement? I mean, I don't understand what your criteria would be for how can I evaluate the validity of a regulation. I understand one thing you've clearly said is that I can't say you've got to do multiple of these things that are listed in the definition, but what am I allowed to tell you?
Your Honor, you have to meet all of the voluminous requirements. You have to show that you can meet, remember, you have to prove all of these initial things. You have to pay the licensing fee, you have to pay a $5 million bond, and facilities will likely do more than one of those things.
No, and I understand you're just telling me what the regulations say. I'm trying to understand constitutionally, what is the standard against which we're supposed to judge the constitutionality of whatever the regulations might be?
Well, Your Honor, they fail the rational basis test if you think that is what applies. But what our position would be is you don't need to go there because you just look at the plain language of the amendment. And remember, again, this amendment changed the definition of a medical marijuana treatment center from what what the statute had been using for dispensing organizations. So there was a clear intent to make this change, to allow anyone, and the legislature cannot, under the guise of public policy, come in and change the plain text of the Constitution. And to the extent there's any doubt that or means or, look at the advisory opinion that you issued before, in which you said these are ministerial things that they're going to be doing. They're not going to be the department would not be making public policy type decisions. And look at the analysis of intent document. It expressly states that a medical marijuana treatment center can do one of the things or all of the things, doesn't have to do all of them. Your Honors, I see that my time is up. We would just ask that we be given a fair chance to register so that we can be evaluated. These licenses that are selling for $50 million, there's something wrong with a system that keeps competition out, products scarce, and prices outrageously high. That is harming Florida's critically ill and terminally ill patients from getting the medical marijuana at reasonable prices, and it is totally contrary to fair market principles. Thank you, Your Honor.
Thank you. Now we'll go to rebuttal.
Your Honor, I spent the bulk of my time walking carefully through the distinction between the amendment's MMPC definition in regard to immunity and in regard to registration, 2 prongs. the legislature is not changing words in the first prong. The legislature is acting under the second. Florigrown ignores that text in the amendment and the full text of the amendment, including the registration requirements in subsection D. But I'd like to spend my rebuttal time answering both Justice Muniz's question and Justice Lawson's question. In regard to Justice Muniz's question, the complaint that was filed was a facial challenge to the statute. This is not a reasonableness test. While the reasonableness is a factor under subsection D of the amendment and having available and safe use regulations, if the court has any question about whether there's a rational basis for the statute, the court should send it back down to the trial court. The House has intervened and it can properly consider that question. In regard to Justice Lawson's question, we're here on a preliminary injunction with a dated record. There are now 22 MMTCs in over 240 facilities. There is no irreparable harm because the application process remains available. Indeed, there are 7 available licenses right now. There, in regard to irreparable harm and an adequate remedy under the law, there's no factual findings in the court's order. And the trial court even initially found that an injunction would substantially alter the status quo. And I urge this court to look to Judge Weatherall's dissent, where he said there's a carefully crafted regulatory scheme, including a statutory scheme, that should be left in place until the conclusion of this litigation. I thank the court for considering all our arguments today, whether it be on the interpretation, whether it be on the lack of conflict with the MMTC caps, and whether it be in regard to the injunction. Thank you.
Well, thank you. We thank you both for your arguments today. And before, this is our last case on the docket, but before we conclude, I would like to express the court's gratitude to all counsel for working with the court to make today's video session successful. We did some preliminary work so everyone would understand the technology, and we tried to minimize the chance that the technology would fail us. So we appreciate all the work that counsel put into that for today's session. I'd also like to thank our clerk, John Tomasino, his staff, and the IT staff of the Office of the State Court Administrator. They obviously spent a lot of time getting all of this together from a technical perspective, and the court is deeply grateful to them as well. So with that, thanks to all, and this session of court is now concluded.